Good afternoon, everyone, and thank you for joining us today, Tuesday, 24th of November, for this Myerson Solicitors Brexit webinar. My name is Terry Moore. I'm a senior associate within the corporate commercial team here at Myerson. I'm joined today by Patrick Byrne, who is an associate within the employment team. In this talk, Patrick and I will touch on some of the key issues which surround small and medium-sized businesses, issues which businesses need to be aware of in anticipation of the end of the transition period on the 31st of December 2020. Before we begin, I'd just like to let you know today's update will last approximately 30 minutes. Throughout the presentation, you're welcome to submit any questions you may have. Please do use the Q&A function on Zoom just by submitting below. We'll try and answer any of those questions at the end. Also, we will be recording the update and we'll circulate the video link to those who have attended today via our Myerson YouTube channel. So moving on with the talk, just to give a little bit of a background, just a quick recap. I'm sure everyone's aware of this already, but just to trace how we got here for a bit of context. On the 23rd of June 2016, the UK held the now infamous referendum and the public voted to leave the European Union. On the 29th of March 2017, Article 50 was invoked, which was the start of the process for the UK's withdrawal. So you probably recall earlier this year, Boris Johnson finally managed to get his withdrawal agreement through Parliament after a majority victory in the general election. So that took effect from the 31st of January 2020, and the UK formally left the European Union on the 31st of January. The very next day was the beginning of the transition period. So the transition period is essentially the period whereby the UK would leave the European Union on a transitional basis. Essentially the same membership elements would remain in place with regards to free trade and free movement of people, and for all intents and purposes it was business as usual for this 11-month period. Now the transition period is due to end on the 31st of December 2020, just over 5 weeks' time. So where are we up to with the deal? At the moment, there's obviously no deal in place at the time of this webinar. Commentators are suggesting in recent publications that the legal text is close to being finalised, although some key issues do remain. There's obviously a bit of a rush against the clock to get this done. There's just over 5 weeks, and the commentators do suggest that everyone is working day and night to get this deal done. It does seem that the list of issues is getting smaller, and a lot of commentators are predicting that a deal will be in place before the 1st of January, but what that looks like, we don't know yet. We will be reporting pretty much immediately as the deal is announced, and we will be reporting on any impact on SMEs resulting from the deal. You can review that on our Brexit hub, which is our sort of hub for publications and news updates, and our website address for that is myerson.co.uk/business/Brexit. So what impact should SMEs expect at the end of the transition period? The good news is that the main body of EU law will remain in force, although there are some notable exceptions and some areas will change for certain. The impact on the SME very much depends on what type of business you conduct. It may be that you need to be concerned about the impact on importing and exporting of goods and services. If you rely on EU nationals for your workforce, you need to think about that. Transfers of personal data is another area which will be subject to some changes. And then generally, you need to just think about any relationships your business has with suppliers, customers, collaborators in the EU countries. One area which will be probably quite crucial for importers and exporters if there is no deal is the potential impact of customs duties and tariffs. Now, as mentioned, it may be that there's a deal and that may give free trade in the same manner as we have had during the transition period. But if there isn't a deal in the next 5 weeks, then World Trade Organization, the WTO rules will apply. That essentially comprises a schedule of tariffs, and those tariffs have been published. They are available on the government website. If you do import or export significant volumes, then we would recommend to take expert advice on this to make sure that you're not going to be hit by unexpected tariffs or duties. Another bit of good news is that there is government-funded training available for this, and we can facilitate this through our UK 200 partners. So please feel free to get in touch with myself or Patrick if you want to take up on that training, and we can explain what's involved. As mentioned, data protection is another area you need to be wary of. You need to ensure that you're compliant if you want to continue to transfer or receive personal data between your business in the UK and any EU countries. Now, quite often businesses don't even realise they are transferring personal data into the European Union. It may be, for example, you host all of your data on a server and your hosting provider is based in the EU. Those rules will change at the end of the transition period, so you need to be careful about that. Additionally, if you share personal data with any of your EU group companies or collaborators, suppliers, customers, and this can be as simple as email addresses, names, etc., contact information, the rules will change, and there are certain requirements you will need to have in place at the end of the transition period. What do those measures look like? Well, the backdrop to this is that the UK is set to become a third country unless there's an adequacy decision. What that means is that unless the EU recognises the UK as a safe harbour for data, then additional rules will apply for international data transfers. If there's no adequacy decision, the free flow of data between the UK and European countries will no longer be possible, and you will need to take additional measures. Now, the good news is that the GDPR, which came into force in 2018, does set out some exceptions to this rule. If you have the explicit consent of the data subject to transfer the data, that is okay, but explicit consent is quite a high threshold. Additionally, you may choose to adopt the appropriate safeguards, which include the standard contractual clauses or, in a group company context, binding corporate rules. Now, they are essentially contracts which aim to give the data subject some safeguards in the event that the data is misused when it's transferred. These derogations, they are quite a complex area of law, and we would recommend to take some legal advice. Please do get in touch with us if you want any further guidance on this. Another area which will inevitably be impacted are supply arrangements. Now, wherever your business may be in the supply chain, you do need to be very careful about this. It's widely anticipated that at the end of the transition period, there are going to be border delays, which will create supply chain problems. There are new border checks coming in because of Britain's departure, and there are safety and standard controls which will be heightened, notwithstanding what the free trade deal, if any, may say. We do anticipate that there will be border delays, so it's important to make sure that you're discussing these supply chain issues with your customers and suppliers. It's anticipated that imports is going to be smoother than exports for a number of reasons. The UK government has actually confirmed that it's going to phase in its own border checks throughout 2021. So 2021 will see an increase in import border checks over the 12-month period, whereas the European Union has not reciprocated on this, and the European Union has stated that it's going to impose those checks from the beginning of 2021. So exporters in particular need to take extra care here, but nonetheless importers should remain vigilant and put into place any necessary contingency plan. It's also worth carrying out a review of your existing contracts in terms of delays, caused by issues at the borders. Who's responsible under your contracts? If you're responsible, what are the repercussions, and do you have necessary measures and contingencies in place to deal with those? Product compliance will become more of an issue again at the end of the transition period. You need to be careful about what contractual assurances you might be given to your customers, and making sure that they are back to back with any, for instance, European manufacturers who might be manufacturing products for you. SLAs and KPIs, these are essentially legal terminology or commercial terminology for service levels and key performance indicators. So if you give contractual promises about lead times, milestones, other performance metrics on a project, is Brexit at the end of the transition period going to make any of those unattainable? If so, again, you need to be careful about what you have in place to mitigate that. I would also recommend to review your existing standard terms and ensure that any new contracts you enter into are carefully drafted and considered. Again, service levels will be important. The 2021 will be an uncertain year, so you don't want to overcommit on any projects. You'll need to mitigate any uncertainty and allow for that buffer if you do, for instance, import goods and supply them on as part of a supply chain. Fixed prices, if commercially possible, I would recommend to try to avoid during this period of uncertainty. Obviously, COVID-19 has hit the economy and likely will continue to do so. Brexit will have an impact on the economy from the end of the transition period as well. The economic uncertainty never makes it a good time for you to be chained to fixed prices. Currency fluctuations may render that difficult to live up to, and as mentioned earlier, the worst case scenario could be that there are duties and tariff increases under the WTO rules. So I would recommend being careful about fixed prices, or at the very least, if you're going to fix them, allow a bit of flexibility in the contract for economic factors which are outside of your control. In terms of disputes, where should these be heard if you have a contract with a European customer? Now, this is not a simple question to answer. This is another area which is contingent on whether there is a deal or not. When the UK was part of Europe, there was a sort of reciprocal arrangement whereby all of the European Union member states recognise each other's judgments. So if you get a judgment against a European company, whether it's a supplier, a customer, a collaborator, enforcing against that company is normally quite a swift process whilst the UK has been part of the EU. Now that will change, and we will be reporting further on this on our Brexit hub. But one thing just to bear in mind is that there are other forms of dispute resolution, and if there is no deal or the deal does not address enforcement issues, then it's worth looking at your contracts to consider whether, for instance, arbitration may give you swifter rights of recovery. And the final point on supply arrangements with regards to Brexit clauses. Now, there's no such thing as a Brexit clause in the legal dictionaries. It's a bit of a construct which lawyers have come up with. All it really means is if there is anything relating to Brexit which may sort of render the original commercial relationship untenable or change the fundamental nature of that commercial relationship, then that may give rise to a right to terminate the contract, suspend performance, or alter the prices or payment terms. So these clauses can be quite flexible, and they can give you a right just to step back and review if it transpires that Brexit does impact on your business relationships in a significant way. At this point, I'm going to hand over to Patrick, who is going to talk a little bit about the EU settlement scheme and some of the immigration rules and how that may impact on your business.
Yeah, thanks, Terry. Hi, everyone. My name's Patrick. I'm in our employment team here at Myerson's, and I'm going to talk a little bit about the impact in the HR area of this topic. I'll start by discussing the kind of immediate impact on hiring processes that you might experience. And then I'll just finish off by talking about some of the broader issues that might crop up further down the line. So, and as we go along, you might have noticed there's a Q&A function at the bottom of your screen. So if you do have questions that occur to you, please feel free to pop them in there and we'll try and answer those at the end. So starting with the EU settlement scheme, and this might be of interest to those of you with EU staff in your workforce, or maybe you're imminently going to be hiring EU staff. As Terry's noted, the transition period is ending at the end of this year. And with that flexible ability for EU citizens to come over here and work with their passport or their national ID card, that's ending. What the settlement scheme is intended to do is to give them a simple, more straightforward mechanism by which they can secure the right to continue living and working here. It's very much voluntary on them, and there are no obligations written within the scheme on employers. So employers can help them out as much or as little as they wish with that. But as we'll go on to discuss, it can be a good idea to strike up a conversation with them about that. So I'll put this timeline in for you to take away if you wish, and we'll be circulating the slides at the end. It just notes some of the key cutoff dates that are coming up. So the EU settlement scheme, as I said, is the more straightforward route for someone to secure their right to work. Now, you have to be living within the country and working here by the 31st of December 2020 to access that scheme. If someone arrives from the 1st of January next year, then they're going to have to try and get the right to work here under a more stricter new immigration system that's coming into force. And another date for people to bear in mind is that, well, it's all well and good if they're living in the country by the end of the year, but they then need to get their application submitted on the government website for the settlement scheme. And the date for that is the end of June next year. And in terms of what the application actually looks like, it's designed to be straightforward and it's designed to be accessible by the average person. So it is supposed to be fairly straightforward. They'll need to give their personal details. They'll need to establish that they have been living in the UK by the deadline. And depending on how long they've actually been living here for, they'll either get settled or pre-settled status. So if they've been living here for 5 years by the 31st of December, they'll get settled status, which is the permanent right to live and work here into the future. If they don't quite have that 5 years, they'll be given a temporary status called pre-settled status. And they can then, as long as they oblige by the rules that come with that, they can then work up to getting the 5 years and securing the right to live here full time. And they'll also receive, obviously, they'll receive confirmation of their status once they've got it. So, but from next year, that's all changing. So that settlement scheme will be closed to people who arrive from January next year. The scheme that's replacing it is much like the one that's already in place for non-EU immigrants. And the purpose of it is to equalize the way we're treating migrants from the EU and migrants from outside of the EU. It's open to various categories of individuals, but 99% of employers will be using it to hire skilled workers. And you'll get a license that's renewable every 4 years. And if anyone is an existing sponsored employer under that scheme, they should be able to continue applying their current license to EU citizens. I've put a few details on this slide about the criteria of the scheme, because obviously it's more challenging than the settlement scheme, and obviously there's a lot more to it than freedom of movement. So the sort of criteria, your business will need to meet certain requirements, which I've laid out here. And obviously, as long as your business qualifies, the vacancy that you are trying to fill will need to meet certain criteria as well. There's a point system there, and you need to hit the requisite 70 points by showing a combination of different factors. So I've labeled a few of them here, but they really all circulate around showing that this job has a certain level of skill to it, has a certain level of qualification or salary or English language requirement. And I've dotted some suggested actions here because I think, well, it will be a topic that affects businesses to differing degrees. Everyone will still have to carry out right to work checks. That obviously won't change, but you'll need to be aware of what documents you can and can't accept. You can keep accepting EU passports for a while into next year, but obviously past the 30th of June, you'll need to be aware of the correct EU settlement scheme document to look at, or if you're planning on using the sponsorship scheme, you'll need to take advice on how you can go about that. Other good measures you can take, if this is at all a concern, is to have sensible caveats in your offer letters and your contracts. So simple wording that requires immigration checks to have been carried out, and in the contract that the person is warranting that they have the right to work for you, and they'll let you know if that changes. That can be something that does come in handy. You know, worst case, they do lose the right to work here. And then finally, I've just dotted down that it's important to plan and communicate, because the deadlines are coming thick and fast, and I think it may have slipped off some people's radars with everything that's been going on with COVID-19 and lockdown. So you don't have to do a lot, but you can, if you do have EU staff, or if you are in the process of hiring them, you can simply touch base with them, see if they're aware of the schemes available, and always help them, you know, in guiding them to government resources. And on our Brexit hub on the Myerson website, we've got a number of guidance sheets and precedents that could help you with that. And then finally, I was just going to briefly touch on a few more indirect topics that might crop up in the coming weeks and months. Obviously, with everything that's been going on with COVID and the economic pressures associated with that, the three topics I've dotted here have been common themes for a lot of employers. With Brexit around the corner as well and the end of the transition period, that could exacerbate things and have a similar impact to COVID. So, you know, you may find there's a need to consult with staff on changing their contracts. You know, that could be the hours that they're working, or it might be a bonus that they're entitled to coming up. Brexit might mingle with COVID-19 as a reason to look to furlough leave as an option and to access the government schemes there. Or worst case scenario, you may find that there are employees or areas of your business that become somewhat redundant as a result of the effects of the wider economy and the impact of Brexit. So planning all of these things in advance, again, can really help you and can avoid making procedural errors that lead to nuisance or costly legal claims. So that is everything I wanted to talk about. I can see that we've got one question on data protection. I don't know, are you happy to field that, Terry? That's one from Sheila.
Yeah, thanks for that, Sheila. Sheila asks, is the current view that the UK will be viewed as a safe harbour from a data protection perspective? there's not a huge amount on this at the minute, really. It's not widely reported. I would hope that the UK would be viewed as a safe harbour, given we adopted and implemented GDPR, which is the same legislation which applies across the EU and does contain a lot of protections for data subjects. So I would hope that they would be quite sensible on this, but there are also political elements to this. We don't know whether this forms part of the, the trade deal which is being negotiated or not. The only point I would make really is just to make sure that, irrespective of whether the UK is subject to an adequacy decision, you do just have your house in order. Just make sure that, to the extent you do transfer data overseas, you've got the correct contractual clauses in place. It's not, it sounds a scarier exercise than it is, but if you do need any help with that, Sheila, or anyone else, just drop us a line.
Yeah, that's great. So just looking at the time, I think we're probably best to wrap things up. We'll be sending this video to you all if you want to recap on any areas of it. And you've also got the link to our Brexit hub, which has lots of useful resources for you. And as always, feel free to contact Terry or I if you want to discuss any questions as well. Great. So thank you very much for joining us, and we hope you found this useful.
Thank you, guys.
Thank you. Goodbye.